the Securities Regulations Code or the Republic Act 8799. Okay, the SRC is found on RA 8799, approved on July 19, 2000 and took effect on August 8, 2000. This repealed the Revised Securities Act or the BP 178 in its entirety and sections 2, 4, 8 of sections 2, 4, and 8 of PD 902-A as amended. Questions. What are the main purposes of the Securities Act or the Securities Regulations Code? The answer. The purpose of the Securities Regulation Code are the following. 1 is to establish a socially conscious free market that regulates itself. 2. Encourage the widest participation of ownership in enterprise. 3. Enhance the democratization of wealth. 4. Promote the development of the capital market. 5. Protect investors. 6. Ensure full and fair disclosure about securities. And lastly, minimize, if not totally eliminate, insider trading and other fraudulent and manipulative devices and practices which create distortion in the free market. Securities required to be registered. What are the securities required to be registered? Okay, securities shall not be sold or offered for sale or distribution within the Philippines without the registration statement duly filed with the Securities and Exchange Commission. The rule, however, is subject to the exception with respect to exempt securities and exempt transactions where the requirement of registration shall not apply. So, let's define securities. Securities are shares, participations, or interest in a corporation or in a commercial enterprise or profit-making venture, and evidenced by a certificate, contract, instrument, whether written or electronic in character. It includes 1. Shares of stocks, bonds, debentures, notes, evidences of indebtedness, assets-backed securities. Number 2, it may also be an investment contract, certificate of interest or participation in a profit-sharing agreement, certificates of deposit for a future subscription. 3, it may be a fractional undivided interest in oil, gas, or other mineral rights. 4, it may be a derivatives like options and warrants. 5, it may be a certificate of assignment, certificate of participation, trust certificates, voting trust certificates, or similar instruments. 6, it may be a proprietary or non-proprietary membership certificates in corporation. And lastly, it may be those that other instruments as may be in the future be determined by the Commission. Okay. Example. Example or a question. X has the following plans. 1. Organize the Tagaytay Country Club Incorporated. 2. Let the club buy a 10 hectare of land for 10 million which will be developed into a sports and health club complete with an Olympic-sized swimming pool, tennis and other courts, bowling lanes, pools, rooms, etc. C. 5 of the 10 million pesos needed to be developed, the club will be raised through the sale of certificate of membership. D. The certificate of membership shall give the purchaser the right to use all club facilities and shall be transferable. It shall not, however, give the purchaser any right in the income or assets of the club. The purchaser must also pay monthly dues. X wants to know whether the certificate of membership is an investment contract and hence a security within the meaning of the Revised Securities Acts or the Securities Regulations Code. What is your opinion? Okay, the answer. A certificate of membership, whether or not the member becomes owner of the assets or profits of the club, association, or corporation, is a security under the code. Consequently, The issuer of these certificates will have to file an application with the SEC in order to register the securities about to be issued to the general public. So, another example. Andante Realty, a marketing company that promotes and facilitates sales of real property through leverage marketing, solicits investors who are required to be business center owner by paying an enrollment fee of $250. The BCO is then entitled to recruit two other investors who pays $250 each. The BCO receives $90 from the $250 paid by each of his recruits and is credited a certain amount for payments made by the investors through the initial efforts of his business center. Once the accumulated amount reaches $5,000, the same is used as down payment for the realty property chosen by the BCO. Questions. Define an investment contract. An investment contract is defined in the amended implementing rules and regulations of RA 8799 as a contract, transaction, or scheme whereby a person invests his money in a common enterprise and is led to expect profits primarily from the efforts of others. Second question. What procedure must be followed under the SRC to authorize the sale or offer for sale or distribution of an investment contract? Answer. An investment contract that is security under RA 8799 must be registered with the SEC before its sale or offer for sale or distribution to the public. The strict regulation of securities is founded on the premises on the premise that the capital market depends on the investing public's level of confidence in the system. Last question. What are the legal consequences of failure to follow this procedure? Failure to register empowers the SEC to enjoin the sale or the distribution of the said investment contract. Kindly read see the Power versus SEC. It is already decided case. Another example. One day, Jerry, doing business under the name Starlight Enterprise, a sole proprietorship, finds himself short on cash and unable to pay his debts as they fall due, although he has sufficient property to cover such debts. He asks you, as his counsel, for advice on the following queries. Should he sell profit participation certificates to his 10 brothers and sisters in order to raise cash for his business? Yes or no? Why? Answer. No. He cannot sell profit participation certificates to his 10 brothers and sisters. A profit participation certificate is a security as defined by the SRC. The issuer, Jerry, is required by law to apply for a license to issue said certificate and should register the same with the SEC. He can, however, procure the financial assistance from his brothers and sisters through the means other than the issue by him of profit participation certificates. Question. What are the classes of securities under the Revised Securities Act? Okay. Answer. The Securities Code divides securities into two classes, which are 1. Exempt securities and securities emanating from exempt transactions. And number 2, non-exempt securities. Okay? Non-exempt securities are those which may be offered for sale or otherwise disposed of to the general public by registration with the SEC, done by the filing by the issuer, dealer, or underwriter of an application complying with the provisions of the code. While the securities exempt from registration consist of those which are called by law as exempt securities, like those issued by the government, by banks, by a receiver, or by a trustee in bankruptcy, or any security or its derivatives The sale or transfer is under the supervision of OIC, HLURB, or the BIR. So, next question. Let's name some classes of securities exempt from regulation or licensing for purposes of sale. Okay, the answer: registration shall not apply to any of the following exempt securities. 1. Okay, any security issued or guaranteed by the government of the Philippines or by any of its political subdivision or agency thereof, or by any person controlled or supervised by and acting as an instrumentality of the government. Number 2, any security issued or guaranteed by the government of any country with which the Philippines maintains diplomatic relations, or any state, province, or political subdivision thereof. Number 3, certificates issued by a receiver or by a trustee in bankruptcy. Number 4, any security or derivatives, the sale or transfer of which is under the supervision and regulation of the OIC or the Office of the Insurance Commission, HLURB, the Bureau of Internal Revenue. Number 5, any security issued by a bank except its own share of stock. Okay, you can read. You can see this RA 8799. While those exempt transactions naman, punta naman tayo sa exempt transactions. So, let's give some instances of exempt transactions under the law. Number 1, first, registrations shall not apply in any of the following exempt transactions. Okay? Actually, mahaba to. So, let's just enumerate some. Okay? At any judicial sale or sale by an executor or administrator, guardian, or receiver or trustee in insolvency, bankruptcy, by the sale of securities to any number of the following buyers: bank, registered investment house, insurance company, pension funds, or retirement plan maintained by the government of the Philippines, or any of its political subdivisions thereof. Okay, those managed by bank or other persons authorized by BSP to engage in trust functions, investment company, or other persons as determined as qualified buyers. Okay, others, you can read the exempt transactions under RA 8799. Okay, let's proceed sa more technical. Short sales. Okay, define or explain short sales. Short sale is any sale of a security which the seller does not own, or any sale which is consummated by delivery of a security borrowed by or for the account of the seller. What is a fraudulent transaction? Okay, it shall be unlawful for any person in connection with the purchase and sale of any security to 1. Employ any device, scheme, or artifice to defraud. B. Obtain money or property by means of any untrue statement of a material fact or any omission to sell a material fact necessary in order to make statements made not misleading. And lastly, engage in any act, transaction, or practice or course of business which operate or would operate as a fraud or deceit upon any person. Question: what is an insider trading? Okay, this is the concept of insider trading. It shall be unlawful for an insider to sell or buy a security of issuer while in possession of material information with respect to the issuer or the security that is not generally available to the public, unless 1. The insider proves that the information was not gained from such relation. 2. If the other party selling to or buying from the insider is identified, thus the insider proves A. that he disclosed the information to the other party, or B. that he had reason to believe that the other party otherwise is also in possession of such information. Remember that a purchase or sale of security of the issuer made by an insider or his spouse or relative by affinity or consanguinity within the second degree shall be presumed to have been effected while in possession of material non-public information if transacted after such information came into existence but prior to the dissemination of such information to the public and the lapse of a reasonable time for the market to observe such information. Okay, I will just give some examples na lang para mas maintindihan natin. Example, Grand Gas Corporation, a publicly listed company, discovered after extensive drilling a rich deposit of natural gas along the coast of Antique. For 5 months, the company did not disclose the discovery so that it could quietly and cheaply acquire neighboring land and secure mining rights to the land. Between the discovery and its disclosure of the information to the SEC, all the directors and key officers of the company bought shares in the company at very low prices. After the disclosure, the price of the shares went up. The directors and officers sold their shares at huge prices or huge profits. Question: what provisions of SRC did they violate? Explain. Answer: the director and officers violated the section 30 of the Securities Regulations Code. The said provision provides that it shall be unlawful for an insider The said provision provides that it shall be unlawful for an insider to sell or buy a security of the issuer if he knows a fact or of special significance with respect to the issuer or the security that is not generally available. Insider means 1. The issuer, 2. A director or officer, or a person controlled by or under common control with the issuer. 3. A person whose relationship or former relationship to the issuer gives or gave him access to a fact or special significance about the issuer or the security that is not generally available. Or number 4, a person who learns such a fact from any of the foregoing insiders as defined in the subsection, with knowledge that the person from whom he learns the fact is such an insider. Kindly see section SEC versus Interport 567 SCRA 354. Question: assuming that the employees of the establishment handling the printing work of Grand Gas Corporation saw the exploration reports which were mistakenly sent to the establishment together with other materials to be printed. They too bought shares in the company at low prices and later sold them at huge profits. Will they be liable for violation of SRC? Why? Yes, of course. They are liable also, for they are also insiders in the eyes of the law. The employees in this case falls within the category persons whose relationship or former relationship to the issuer gives or gave him access to a fact of special significance about the issuer or the security that is not generally available. Okay, last. Miss O.B. was employed in Mass Investment Bank. WIC, a medical drug company, retained the bank to assess whether it is desirable to make a tender offer for the OP company, a drug manufacturer. OP overheard, in the course of her work, the plans of WIC or WIC. By herself and through associates, she purchased the OP stocks available at the stock exchange priced at 20 pesos per share. When WIC's tender offer was announced, the OP stocks jumped to 30 pesos per share. Thus, OB earned a sizable profit. Is OB liable for breach of and misuse of confidential or insider information gained from her employment? Why? Yes, Miss OB is liable for breach and misuse of confidential or insider information because she is considered an insider under the law. Okay? Ms. OB is also liable for any damages to any seller or buyer with whom she might have dealt with in an amount not exceeding triple the amount of the transaction plus actual damages, attorney's fees not exceeding 30% of the award. Last question. What is a tender offer? Okay? What instances is a tender offer required to be made? Tender offer means a publicly announced intention by a person acting alone or in concert with others to acquire equity securities of a public company. Okay? A person is required to make tender offer for equity shares of public company in an amount equal to the number of shares that the person's intends to acquire in the following circumstances. 1. The person intends to acquire 15% or more of the equity shares of a publicly company pursuant to an agreement made between or among the person and one or more sellers. 2. The seller intends to acquire 30% or more of the equity shares of a public company within a period of 12 months. And lastly, the person intends to acquire shares that would result in ownership of more than 50% of the equity shares of a public company. Okay? Let's just give an example. Okay, example lang. Union Mines has total assets of 60 million with 210 stockholders holding at least 100 shares each. The company has two principal stockholders, ABC, which owns 60% of the shares of stock, and XYZ, which owns 17% of the stock. ABC in turn is owned to the extent of 21.31 by Acme Incorporation, 29.69 by Golden Boy Incorporation, and 9% by XYZ, and the rest by individual stockholders. None of the parties is a publicly listed company. XYZ now proposes to buy Acme and Golden Boy shares in ABC, which would give it direct control of ABC and indirect control of Union Mines. Is the proposed acquisition by XYZ subject to the mandatory tender offer rule? Why or why not? Explain. No, the proposed acquisition by XYZ is not subject to the mandatory tender offer rule. Okay, this is the reason. Tender offer means a publicly announced intention by a person acting alone or in concert with other persons to acquire equity security of public company. In the given case, okay, none of the corporation involved is a public listed company. As such, the rule on mandatory tender offer rule does not apply.